Come back. Well, one day before the turn of the new year, Indonesian President Joko Widodo issued a government regulation in lieu of law, essentially to replace the previous jobs creation law passed in November 2020, but deemed unconstitutional and pending a revision as ordered by the Indonesian Constitutional Court. The government's emergency law has been heavily criticized, with many seeing the move as a way to bypass the legal process in Indonesia. Now, it all began with the jobs creation law, which came into effect on November the 2nd, 2020. The law, which was over 1,180 pages long, covered various regulations, including investment requirements, ease of business, land permits, and labor laws. But then the law sparked protests among labor workers who argued that it diminished workers' rights, including articles such as those which allowed companies to hire workers based on temporary contracts for an undetermined amount of time. Previous regulations stated that companies can only give workers 3 consecutive contracts within a 5-year limit, after which companies would need to hire them as permanent workers, but the jobs creation law removed that regulation. And then following that, in November 2021, the Constitutional Court then ruled the jobs creation law to be conditionally unconstitutional, ruling the procedures for its formation to be defective and then ordering the House of Representatives to revise the law, giving them 2 years or until November 2023 to revise it. But then on the 30th of December 2022, right before celebrations of New Year's began, Indonesian President Joko Widodo issued the number 2 2022 government regulation in lieu of law, essentially to replace the previous jobs creation law that is still under review. The government argued that it was a necessary emergency measure to face the dire economic challenges in 2023, with many institutions forecasting a global recession this year. However, it still included a number of controversial articles regarding employment and workers, including allowing companies to freely outsource work without bounds, while also allowing companies to increase weekly working days to 6 from the previous 5. A number of politicians and experts also criticized the move, saying it had essentially bypassed the legal process, bypassing the review ordered by the Indonesian Constitutional Court.
Undang-Undang Cipta Kerja itu menurut putusan MK kan harus diperbaiki, bukan dikeluarkan Perpu sebagai produk hal ihwal kegentingan memaksa. Apalagi kalau kita lihat ya, waktu 2 tahun itu sudah mau habis. Jadi terang bagi saya Perpu ini adalah upaya untuk mencegah agar Undang-Undang Cipta Kerja tidak inkonstitusional secara permanen karena waktunya mau habis. Dan tidak juga terpenuhi ini hal ihwal kegentingan memaksa karena waktu untuk memperbaiki 2 tahun lalu, kemudian pasal-pasalnya terlalu banyak ya. Tidak lumrah Perpu yang mendesak hal ihwal genting memaksa gitu ya, dibuat panjang-panjang hanya untuk kemudian menyelesaikan masalah sesaat.